Good morning, everyone. Welcome to today's webinar. I'm Rashmi, and today the topic of webinar is property development in SMSF. The question of whether an SMSF can be in the business of property development is an intriguing one. In this presentation, we will examine whether an SMSF can do property development. Specifically, we will see whether it can contravene SIS Act and regulations. I will also try to illustrate with few examples to give you more clarity on the topic. Before we proceed further, I would like to tell you that I have uploaded handouts which you can download and refer to it after the presentation. This slide is a disclaimer. I will just read out for you, won't take longer. This presentation is for information purposes only, and it does not give any legal, financial planning or other professional advice. And also, material in this presentation should not be relied upon as such. So the presentation provided in this presentation is general in form, and formal legal or financial planning advice should be sought in particular matters. Also, we don't accept liability in respect of this information. So let's move on and start the agenda. As you all know that property is becoming an increasingly popular investment choice in the SMSF sector because trustees seeking to diversify. One issue that has long been debated is whether an SMSF can be in the business of property development to improve the retirement outcome of members. First issue that needs to be considered is whether the SMSF can be in the business of development or not. We will also consider being involved in the property development business breach the sole purpose test or not, which is very important to consider. I will also talk about the activities of the trustees. This is what the ATO look into. We will also discuss the issues which ATO has listed to determine if there has been a breach or not. There are a few other points which I will discuss, like the fund could choose to either develop the property itself or to engage a developer to do all the development work. Also, whether the development is a one-off event or it can occur more than once. Then I will take a few examples and discuss few real-life scenarios. I'll first start with business test. I think the first hurdle that will be faced is whether the SMSF is considered be in the business of development and whether this would breach the sole purpose test. As you are aware, investments must be for the sole purpose of providing for benefits in retirement. Generally, an SMSF may own business property but should not be in the business of running a business. So what does the ATO look for when determining if there is a business in operation or not? I think the factors the ATO will generally have regard to are reputation, scale, view to profit, whether it's in a business-like manner, and intention to engage in business. I will take one by one. Let's start with reputation. A one-off event may be a business, but generally, reputation is necessary for the business test to be passed. That is, multiple events over a period of time. Second factor is scale. The bigger the scale, the more likely a business is being carried on. It is important to note that developing property generally involves considerable scale. Another factor is view to profit. As you all know, a business undertaking is done with the usual expectation to make money. In this situation of property development, and the superannuation, it is to increase benefits of members. Business-like manner criteria. It involves formality in how activities are organized, how sets of accounts are there, separate banks accounts, registration if necessary. And last factor is intention to engage in business. You need to look at the intention, whether you must have decided to start a business. The ATO will determine this test based on a combination of these in a particular circumstances. If the property development is a one-off event and it is without the use of related parties to assist in the development, then it may be considered, it may not be considered a business. But the other situation can be if the development is extensive, which involves a number of properties, then the ATO may see this as a business venture which potentially breaching the sole purpose test. Another situation can be if the trustee is already involved in property development on a commercial basis. So the fund activities of property development could be seen as an extension of those activities, resulting in breaching the sole purpose test. There is a case, Scott versus Commissioner of Taxation 1966. In that case, the High Court found that a solicitor also involved in property development set up a superannuation fund. Of course, the superannuation fund was set up under previous rules. The superannuation fund that made money from the property development was merely a continuation of Scott's property business. Therefore, it was not a superannuation fund at all. So the real question is, when is the line crossed? It is very important to understand when this line is crossed. The next slide is about the sole purpose test. As you all know that Section 62 of SIS Act requires the trustees to ensure that the SMSF is maintained solely for one or more of the allowable core purposes. It is in addition may also be maintained for one or more of the allowable auxiliary purposes. We need to understand first what are allowable core purposes and what is included in allowable auxiliary purposes. The allowable core purposes are the provision of benefits for each member on their retirement, attainment of a prescribed age, or death prior to retirement or attaining the prescribed age. The second section of allowable purposes are the allowable auxiliary purposes, which are the provision of benefits for each member on termination of employment, cessation of work due to ill health, and there are other purposes too included in that section. So the conclusion is the sole purpose test is a conceptual test that when satisfied demonstrates that SMSF has in fact been maintained solely for allowable purposes. Also, if you look at the auditor's report, it requires the auditor to separately state about the procedures. I will just read that part of the audit report for you. It states the procedures included testing that the fund's governing rules establishes the fund solely for the provision of retirement benefits for fund members or their dependents in the case of a member's death before retirement. Also, the trustees of an SMSF are required to maintain the fund in a manner that complies with the sole purpose test. The sole purpose test should comply at all times while the SMSF is in existence. It extends to all the activities of the SMSF, including the contributions, whether they're investing the SMSF assets, whether it is administering the funds, etc. Let's go back to the property development business and analyze the sole purpose test in relation to that. So, does being involved in a property development business breach the sole purpose test? This is a very important question. Business-like activities do not automatically breach the sole purpose test. This fact is clearly evident from ATO's acceptance. ATO has long accepted that trading in shares and equities does not breach the sole purpose test. This does not breach the sole purpose test even where undertaken in a business-like fashion. The ATO's website contains a document entitled Carrying on a Business in a Self-Managed Superannuation Fund. It clarifies that merely operating a business in an SMSF does not breach the law, but it is necessary to avoid breaching the sole purpose test. Of course, if you're operating a business out of an as SMSF, will lead to great scrutiny by the ATO of the fund. Moving on further, the next factor which needs to be considered is activities of trustees. Activities of the trustees is what the ATO will look into, not the mere fact that a business is being operated. The ATO has listed the following four as issues in determining if there has been a breach or not: whether the trustee employs family members, whether the trustee carries on a business that relates to activities that are commonly carried out as a hobby or pastime, whether the business carried on by the fund has links to associated trading entities, and whether the superannuation fund assets are available for the private use and benefits of the trustees or related parties. Looking at the first of these, which is whether the trustee employs family members. In this case, you need to consider the rationale for the person's employment, and also it is very important to consider whether if it is at arm's length. The ATO is considered that the fund does not operate in a way that provide benefits other than retirement benefits to members or related parties. Let's say if related parties are employed on non-commercial terms, then it will be seen as providing benefits to related parties. It also indicates that the development provides non-retirement benefits. Second issue is whether the trustee carries on a business that relates to activities that are commonly carried out as a hobby or pastime. So this factor relates to the business test. If it is in the nature of a hobby, it will generally not be considered a business. But it is important to note that the property development is unlikely to be seen as a hobby. Third issue, which was listed by ATO in determining if there has been a breach or not, is whether the business carried on by the fund has links to associated trading entities. This factor relates to the ban on related party transactions. If a related business is providing material for the build or providing services for building, then this is likely to be in breach of the requirement. And this would make it difficult for a person that is involved in the property development, whether the property development it is in the primary business or not, to be involved in developing property through the SMSF. So the ban on related party transaction would also make it hard for the SMSF trustees to take advantage of preferable pricing from related parties. This would result in decreasing the cost of development. The last issue is whether the superannuation fund assets are available for the private use and benefit of the trustees or related parties. The final issue of ATO concern is that members and related parties do not enjoy a present benefit of the development. Let's take an example. This involves a fund that builds a skiing lodge, which is rented out at commercial rates for the fund. If the lodge was then made available to members or related parties at a discount, this is a prohibited benefit. What the ATO will be looking for then is other motives behind the development that breach the sole purpose test. Those SMSFs wishing to develop property must ensure they are doing it for legitimate purposes. They must ensure they're not avoid breaching the related party rules, and ensure that no ancillary not permitted benefits flow to members or related parties. Another important area that needs to be given consideration is structuring the development. If the fund already owns the land, it could develop it in a way that does not breach the sole purpose test or the other provisions. So the fund has got two options. The fund could choose to either develop the property, engaging contractors to do the work and purchasing building material, but not from the related parties. The other option would be to engage a developer to do all the development work. I think from a compliance position, it is simpler to engage a recognized developer for all the work, so the fund is not involved in the business of developing property and potentially breaching the sole purpose test. Second consideration should be given to borrowing money. The fund could borrow money to finance the purchase of the land, but would not be able to use those borrowed money to develop the land. This would change the nature of the asset, and the provisions prohibit this use. So, if the fund borrows to purchase the land, it must use its own funds to develop the land, which that needs to be given consideration while you review the investment strategy and consider whether it is a worthwhile option or not. But the problem is, in either case, if a developer is engaged to develop the property, it will not be possible for the developer to hold a charge over the property. So it may be difficult to find a developer willing to take on the financial risk without security in place. This may require private security over other assets to avoid breaching the no charges requirement. There is an alternative structure to this. An alternative structure would be to use a unit trust arrangement where the fund invests in a unit trust that holds the development land. As this is likely to be a related party to the fund, the unit trust setup must meet the exception to the in-house asset rules. The rules are set out in Regulation 13.22c. This requires the unit trust to be a passive investor, which involves engaging others to do the actual property development. Moving on further, we'll discuss the extent of development, whether the development is a one-off event or it can occur more than once. There are two situations, whether the development is a one-off situation and the other one is whether developments occur more than once. Let's take the first one, where the development is a one-off situation with work outsourced to an unrelated party, then the fund is likely to not breach the sole purpose test. This shows that the investment is relatively passive and the fund is merely extracting the value from the asset. But where development occurs more than once or the fund is heavily involved in the actual construction of the property, then this may be problematic. Reputation may suggest, which we have already discussed in business test, the fund has now moved into the business of property development and away from being a passive investor. If the trustees run a business of property development, this is even more the case. The Scott case, which we have already discussed, again indicates the court may find it is merely a continuation of their business activities and not the management of a superannuation fund. This would mean the fund is no longer a qualified fund. Let's move on further and discuss few other important considerations like investment strategy and trust deed. The sole purpose test, which we have already discussed, is not the only issue that SMSFs interested in developing property need to consider. The investment must also be permissible in the fund's investment strategy and by the fund's trust deed. So SMSFs are not, in fact, are prohibited from carrying on a business, but the business must be allowed under the trust deed and operated for the sole purpose of providing retirement benefits for fund members. Also, it is not simply a matter of changing the investment strategy to suit the new purposes. The trustees must decide whether an investment is good for the fund or not. If there is only one member, this may not be an issue. But if there is more than one member, their investment needs must also be considered. Property development often requires a significant portion of the fund assets or involve borrowings. Trustees need to consider whether it is prudent to be heavily reliant on a single asset and the speculation from developing property. Now, it is important, to consider sometimes property development may fail with significant ramifications for the members. So these issues must be considered by the trustees before committing fund assets to the development. If borrowings are necessary, the limited exception to the ban on borrowings must be met while also meeting the fund's investment strategy. In the end, the investment needs to be a good one. To decide whether it is a good one or not, you need to consider the actual demand for property in the area. You need to consider the cost of development, which also includes like the council and legal cost. You need to also consider the other investment considerations like the return, etc. There is no point getting involved in such a development if the economic conditions are not right. Consideration should also be given to what is permitted by the trust deed. Many trust deeds will prohibit the running of a business through the fund. A trust deed may also not permit borrowings to be entered to. Therefore, a close consideration of the trust deed is a must. It may require a change to the deed to permit borrowings, and the cost of changing the trust deed should be part of any cost associated with the project, and you need to consider this when you are analyzing the investment, whether you have to go for it or not. Considering all the factors we have discussed today, the conclusion is, I think, it appears that a small one of property development through an SMSF that does not breach the sole purpose test is permitted, but everything must be aligned right. A fund, though, needs to make serious consideration as to whether a property development with all its inherent risk is the best investment choice for the fund or not. Just because it is permissible doesn't mean it is a good idea. Um, I will take a few examples which will give you more clarity of the topics and the tests. Example 1, the ABC SMSF owns vacant property on the outskirts of Brisbane. The area has seen recent development and is also earmarked as an expansion zone for residential housing. The trustees of ABC Fund review their investment strategy, which is very important, and find that developing the land is a worthwhile investment choice. Having no experience in the property development, what they did right, they engaged XYZ Constructions to build a house and collect all amenities. All developments are paid from funds available to the SMSF. In this case, this is a one-off event which is unlikely to breach the sole purpose test, and I think this is fine and should be permitted. Let's take another example. Example 2. In this example, the trustees subdivide the land into 3 parcels. They sold off one parcel to raise funds to develop the other 2 parcels. The trustees manage the building project themselves. When finished, they sell one of the remaining properties for a profit and retain the third as a rental income producing property. In this circumstance, the trustees need to be careful that in running the development themselves, they do not breach the sole purpose test. There is another option to avoid breaching the sole purpose test, which is hiring a lead contractor. Hiring a lead contractor may be one way of making sure that they do not breach the sole purpose test. In this case too, even though there are multiple properties involved, if the SMSF they are building at around the same time, they are unlikely to breach the sole purpose test. Moving on further, example 3 is about where one of the trustees is in the business of property development. In this example, the trustees of ABC SMSF review their investment strategy and find that developing the land is worthwhile. One of the trustees is in the business of property development and takes over the day-to-day building project. He's more into the property development means. In this case, the trustees must be careful not to purchase products from related companies to avoid breaching the SIS rules. They also run the risk that the ATO will treat the fund as being another building project of the trustee because the trustee has got building experience and find the fund non-compliant. I think it may be better to appoint an unrelated developer to avoid the risk of breaching the SIS requirements. I'll take this last example, which is example 4. In this case, after an initial property development, the ABC SMSF considers borrowing money to purchase property to develop it into residential property, and they seek advice from the advisor. As an advisor, you need to caution them as this is another development. The ATO may consider that the fund is becoming a property development entity rather than a superannuation entity, and also there may be a risk to their complying status. You have to also warn them that if they use borrowings to purchase the land, they will not be able to use additional borrowings to develop the land because this would be a breach of the ATO's rules on borrowings being for a single acquirable asset. This is the end of the webinar. I hope you have enjoyed. If you have any questions, please email me at rushme@trustdeed.com.au. Thanks for your time and have a great day. Do remember to email me, if you're not sure about anything, and if you have any questions at my email ID, which is on the last slide of the presentation. Um, Again, thanks very much for your time. Bye. Take care.